Thank you, Mr. Speaker, and I do want to thank my friend and colleague, Congresswoman Walters. It's a reminder again that Vietnam has not lived up to the agreement they made in Paris to end the Vietnam War. They promised they would turn over remains. They promised they would give list of our POWs and MIAs. They lied. They didn't do that. They still have that information. In fact, there was 1 year I agreed with the Chamber of Commerce position, National Chamber of Commerce, on most everything, but I disagreed on a trade agreement with Vietnam because I could not vote to give some special deal to people that will not honor their agreements, that lie about Americans dead and who were POWs and missing in action, and remains of which they know and have never disclosed. So this is one more reminder that one thing we can do in this House is show courage and say we're not dealing with countries, no special deals at all with countries that harm Americans. We need to protect our own. And I'm so glad my colleagues on both sides of the aisle are calling attention to that fact, led by Congresswoman Walters. It's important to remember. And I hope and pray that we will do the right thing here in the House. I know the President has a heart for getting Americans back when they've been improperly detained, or in some cases when they've been properly detained, but especially if they're being mistreated. So Vietnam needs to wake up, and this House and the Senate and the President need to make abundantly clear to Vietnam that economically we're going to come after you. You better let our people go. I also want to address a matter tonight. Having been a former judge, when I hear courageous judges stand up for the Constitution, or I read opinions wherein courageous, intelligent judges have taken a stand for the Constitution, it warms my heart, it inspires and encourages me. And I've heard many friends in the media who have given accolades to a Virginia federal judge named T.S. Ellis, not T.S. Eliot, but T.S. Ellis, who was a judge who was handling a case involving Paul Manafort. And this is from a May 4th article of Jeff Murdoch. It says, a Virginia federal judge Friday blasted prosecutors from the Office of Special Counsel Robert Mueller, demanding to know how decade-old bank and tax fraud allegations against former Trump campaign chairman Paul Manafort, I think he was chair for about 100 days, but how he could relate to Russian election interference, which of course was 2018 or 2016. You don't really care about Mr. Manafort's bank fraud, unquote, District Judge T.S. Ellis said during a morning hearing. Judge Ellis said prosecutors were interested in pressuring Mr. Manafort because he could provide information that would lead to President Donald Trump's, quote, prosecution or impeachment, unquote. At times, Judge Ellis appeared frustrated and even lost his temper with attorneys from Mr. Mueller's team. He grilled them on how allegations about or against Mr. Manafort for activities, the copy I have ends there, but it says, quote, how does bank fraud in 2005 or 6 have anything to do with coordination with the Russian government? Judge Ellis said, what is really going on, it seems to me, is that this indictment is to put pressure on Mr. Manafort, but in and of itself has nothing to do with your appointment, unquote. Judge Ellis appeared to agree with the defense, but did not issue an immediate decision. He repeatedly barraged prosecutors about their authority to pursue decade-old charges against Mr. Manafort. At one point, Judge Ellis asked how the Manafort case differed from the FBI raid on President Trump's attorney Michael Cohen. The Cohen matter was referred by Mueller's team to prosecutors with the Southern District of New York for investigation and possible prosecution. In contrast, the Manafort case is being handled directly by Mr. Mueller's officer. He then appeared to guess the prosecutor's answer, saying the Cohen investigation did not, quote, further our core effort to get Trump, unquote. Later, Judge Ellis summarized prosecutor Michael Driven's argument as, quote, we said what this investigation was about, but we are not bound by it, and we were lying, unquote. He then looked at Mr. Driven and said, come on, man, referencing a catchphrase from ESPN's NFL pregame show. Further down at issue in the memo is the definition of arise. The order gives the special counsel the authority to investigate any matters that, quote, may arise directly from the investigation. But prosecutors admitted Friday that the Manafort probe had been ongoing by the Justice Department before Mr. Mueller was appointed special counsel. Mr. Driven said the charges against Mr. Manafort came because they had to, quote, follow the money, unquote, to discover Mr. Manafort's financial records and ties to Russia through his lobbying work in the Ukraine. The comments provoked a sharp rebuke from Judge Ellis. Quote, it didn't lead to that, unquote, he said of the Manafort charges and Russia probe. Quote, it was given to you by the Department of Justice, unquote. Well, that sounds like a courageous judge, Judge T.S. Ellis. Sounds like a judge who calls them as he sees them. But, as the saying goes, where the rubber meets the road, his courage, his constitutional conviction took a back seat to convenience. So he got accolades for calling out the Mueller investigation. But it is unconstitutional. Mueller has taken an investigation. He was not appointed by the president. He was not appointed by the Attorney General. He was picked by the same guy that was involved in the Russia investigation of Russia's effort to get uranium. He hired another lawyer named Weissman that was involved in that investigation. They have all kinds of ties together. They have all kinds of reasons to cover for each other. But the fact that Rosenstein is acting or as Assistant Attorney General, Deputy Attorney General, the fact that he wrote a memo saying fire Comey and the president acts on that memo and fires Comey based on Rosenstein's recommendation or with his recommendation, and then Rosenstein uses the president's action in accordance with Rosenstein's memo to say that probably was obstructing justice. We need a special counsel. Are you kidding me? There has been a failure of justice and of the justice system. And Federal District Judge T.S. Ellis saw that, and he commented on it. And when he had the chance to use the Constitution and say, enough already, justice has run amok, and Paul Manafort probably guilty of some of the things charged here, if not all of them, but you are not the one authorized to prosecute. The DOJ already had this investigation. It did not arise because of the special counsel, but the special counsel took it over, showing again his lack of integrity as well as that of Mr. Weissman. They had limitless, basically, authority given to them, which is unconstitutional. And Judge Ellis, in his opinion, where he ran away from his courageous words in May, said in part in his opinion, the intended purpose, and he does a good account of the 1978 law creating special counsels. He said the intended purpose of the 78 Act was to create a mechanism for the investigation and prosecution of high-ranking government officials. In 1988, the Supreme Court upheld the constitutionality of the 78 Act despite substantial separation of powers challenges, which, by the way, just because one Supreme Court says one thing, they're not 100% right all the time. That's why they reverse themselves frequently. But as he pointed out, Congress reauthorized the 78 Act for the final time in 1994. It's important to note that despite the fact that Morrison, the case that took this up, was decided 7-1, Justice Scalia's dissent presented a compelling and powerful argument against the constitutionality of the 1978 Act, beginning with an eloquent description of the founders' motivations in enshrining separation of powers principles in the Constitution. Justice Scalia's dissent went on to describe ways in which the 1978 Act infringed upon executive power. And this is from that dissent from Justice Scalia, a great man, funny guy, great sense of humor, but brilliant intellect, and I miss him very much. Justice Scalia said the independent counsel's investigation was commenced not necessarily because the president or his authorized subordinates believe it is in the interest of the United States, in the sense that it warrants the diversion of resources from other efforts and is worth the cost in money and impossible damage to other governmental interests, and not even, leaving aside those normally considered factors, because the president or his authorized subordinates necessarily believe that an investigation is likely to unearth a violation worth prosecuting, but only because the Attorney General cannot affirm, as Congress demands, that there are no reasonable grounds to believe that further investigation is warranted. The decisions regard the scope of that further investigation, its duration, finally, whether or not prosecution should ensue, are likewise beyond the control of the president and his subordinates. But he goes on, quoting Justice Scalia, quote, if to describe this case is not to decide it, the concept of a government of separate and coordinate powers no longer has meaning because it is ultimately irrelevant how much the statute reduces presidential control, unquote. Of course, any impingement on presidential control over the executive branch was unconstitutional. Justice Scalia also noted significant appointments clause problems with the 78 Act, arguing the independent counsel was not an inferior officer because neither the president nor the attorney general could remove the independent counsel. Ultimately, however, Chief Justice Rehnquist and the other justices involved in the case were not of the same mind as Justice Scalia. Court ruled 7-1 that the 78 Act passed constitutional muster, even though I would submit parenthetically it really didn't, but including the appointments clause. In 1999, through a bipartisan consensus, Congress agreed to allow the 94 Reauthorization Act to expire. Lawmakers at that time concluded the 94 reauthorization was seriously flawed in several important respects, as experience had shown. Both Republicans and Democrats had come to the conclusion that in practice, the 1994 Reauthorization Act and its predecessors had become more often a political weapon to be unleashed in the ongoing, indeed escalating culture wars, than a tool for ferreting out and prosecuting crimes ostensibly committed by high-ranking government officials. Later in 1999, the DOJ, acting pursuant to distinct statutory authority, promulgated regulations to replace the procedure set out in the Independent Counsel Reauthorization Act of 1994. Thus, to provide a special counsel with a large budget, tell him or her to find crimes, allows a special counsel to pursue his or her targets without the usual time and budget constraints facing ordinary prosecutors, encouraging substantial elements of the public to conclude that the special counsel is being deployed as a political weapon. Furthermore, although the regulations require the Attorney General to provide a special counsel with a factual statement of the matters to be investigated, notably missing from the regulations any requirement the Attorney General specify any particular crime or statutes that are believed to have been violated. And he goes on in his opinion, I think 31 pages, but he also comments, given the investigation's focus, talking about Mueller's, on President Trump's campaign, even a blind person can see that the true target, special counsel investigation, President Trump, not the defendant. Further, he says, the wisdom of allowing all links between individuals associated with President Trump's campaign and the Russian government to be subject to investigation, irrespective of how stale those connections might be, is seriously in doubt. Nevertheless, he says, the grant of investigatory authority is written broadly and does capture the connections at issue in this case, which the president Judge Ellis had already talked about. It was too broad. And when you look at the people Mueller has hired, not content to have hired, 17 lawyers, 2 of them left, I read recently, as I understand it. He went looking for somebody else that hated Trump as much as he did and Weissman did, and was successful. Apparently the 2 that left didn't hate the president as much as Mueller wanted them to, which is laws in having someone so unaccountable. Unaccountable because they answer to a man who is in, well, it's an old word, we come from cahoots with Mueller and Weissman in the original Russia investigation that let Russia end up with 20+% of our uranium, knowing they were acquiring it illegally. The Obama Council on Foreign Investments in the U.S. voted to let them go. Well, sure, because Mueller and Rosenstein, Weissman, they made sure that their guy behind the scenes wasn't talking. They kept the information quiet about Russia's illegal actions. And, gee, that ended up leading to $145 million in contributions to the Clinton Foundation. A lot of money changed hands. Pay to play, some people call it. And we know for certain that Hillary Clinton's private server was hacked. And the fact that the current FBI director, Director Wray, would allow a statement to go out last week fraudulently has not cleaned itself up yet. Yeah, there have been some people fired, some people demoted, some people moved over. It is still fraudulently deceptive and dishonoring the hard, honest work of thousands and thousands of FBI agents across this country. The Intel Community Inspector General and his investigators, they learned that Hillary Clinton's private server was, in fact, 100% certainty hacked. It was reported by Richard Pollack, and I know who hacked, and I know where the information went. And I can't dispute what Richard Pollack wrote last week. Chinese, he said, their intel, they were getting every one of Hillary Clinton's messages, including some of our most sensitive, classified information. Now, I didn't remember the story from November 6th of 2016, but I saw it recently, and it pointed out Hillary Clinton was not only was she exposing our nation's secrets and those who work secretly for our federal government around the world, she was exposing people to extreme danger and potential loss of life through her unsecured, illegal, and turns out criminal use of that server, not to mention the obstruction of justice when she got a subpoena and had the information sought destroyed. But the good thing for her was that her friends controlled the Justice Department and they hated Donald Trump, and they were going to do everything they could to help her get elected. And that's why I knew Peter Strzok was lying when I asked him about the investigator of the Intel Community IG, Frank Rucker, coming to him and Dean Chappelle and telling them we now know for certain China has hacked all of Hillary Clinton's emails coming in and going out, and gave them specifics. And we know Peter Strzok, we know from his text, from all he was doing everything he could to protect Hillary Clinton from criminal prosecution and to help her defeat whoever the Republican would be, and especially Donald Trump. So it was certainly a lie when he says, I remember Frank Rucker coming over and briefing. I don't remember what he briefed about. He does remember what he briefed about, because when he heard those searing words that Hillary Clinton's server has been for certain hacked, he knew there was a problem. And he covered it up. It takes courage to clean up a dirty justice system, especially when the dirt is at the very top. I was brokenhearted to read the words in Judge Ellis's opinion, a man that's clearly very intelligent, stays on top of the law, saw wrongdoing, saw impropriety, and I would compare him. I'm tempted to compare him. I won't compare him to Pontius Pilate, because then some liberal would say, but that means Gohmert saying Manafort is Jesus, and I'm certainly not ever going to say that. I know Jesus. Jesus is a friend of mine. He's my Savior, and I can promise you Paul Manafort is no Jesus. But the action of a judge saying, I see a problem with your prosecution here, and then refusing to use the power within your control to right the wrongdoing of a justice system, and in this case, the unconstitutionality. It defies the judge's own words when he says, "Let us hope the people in charge of this prosecution, including the special counsel and the assistant attorney general, are such people." Because just before he had said, the case is a reminder, ultimately, our system of checks and balances and limitations on each branch's powers, although exquisitely designed, ultimately works only if people of virtue, sensitivity, courage, not affected by the winds of public opinion, choose to work within the confines of the law. And then he says, let us hope the people in charge of the prosecution, including the special counsel and the assistant attorney general, are such people. And I can tell you, Mr. Speaker, they're not. Judge goes, although this case shall continue, that is heartbreaking. As a former judge and Chief Justice, you want people who are in judicial positions to have the courage to do the right thing. These people in charge of a runaway prosecution are attempting to commit a coup d'etat. They are engaged in a civil war to take down a president, the origins of which operation were fraudulent and were paid for by Hillary Clinton and the Democratic Party. What has happened to the Department of Justice at the top and the FBI at the top is heartbreaking to people that have spent their lives dedicating to truth, justice, and our American Constitution. It turns out Judge Ellis, brilliant, knowing, intentionally walked away from his responsibility and did not show himself to be a person of virtue, sensitivity, and courage, not affected by the winds of public opinion. That's a tragedy.